because we're talking about you, and it's only fair that you get to hear what's transpiring since these are your cases.
Yes, sir.
I want you to know, I don't know anything about your case. All I know is that you've now, as of 3/26, yesterday, you picked up a failure to stop and give information. What happened? Or, well, hold on. You have the right to remain silent. Anything you say can or will be used against you. Okay.
On March 25th, 2025, officers were dispatched to 15357 Wallaceville Road in Harris County, Texas, regarding an FHDI call. Upon arrival, the officer spoke with the complainant, who stated that she followed the defendant after the defendant's vehicle hit her twice and failed to stop and give information. The complainant stated that she was driving southbound on the East Sam Houston Parkway, and the defendant failed to drive in her lane and sideswiped her, causing the vehicle damage to the right side panel of the defendant's vehicle. The complainant stated that she blew her horn several times for the defendant to stop, and the defendant refused. The complainant followed for approximately 3 miles to 15242 Wallaceville Road, and the complainant and the defendant exited their vehicle, and the complainant told the defendant that she hit her vehicle and needed insurance information. The defendant then told the complainant no, and that she was getting something to eat. The defendant went inside the business, exited, and then entered her vehicle and attempted to drive away. The complainant blew her horn several times to get the defendant to stop and told her the police were coming, but the defendant ignored the complainant. The defendant then began to put her vehicle in reverse and proceed backwards, hitting the complainant's vehicle a second time. The complainant.
So are you telling me that now it was intentional?
Sure. The complainant moved her vehicle to avoid being hit and followed the defendant. The complainant flagged the police down to identify the defendant as the person who struck her vehicle. The estimated damage from the complainant was around $4,000, and the defendant stated she didn't stop because she was hungry and colored.
And what?
Colored.
Colored.
Yes, Your Honor.
Can you look up to see if she has a valid Texas driver license?
Yes.
Ms. Gill, I'm going to find that there is sufficient probable cause to go forward with your case. Not only are you on a felony probation for assault of a peace officer, not only are you on felony probation for injury to a child under 15, but you pick up, after both of those, an evading arrest in a motor vehicle, and now an FSGI. I am taking away your privilege to drive. You will now be signing an affidavit with me today, promising me you're not going to drive. I don't give a rat's behind what your excuse is. If I find that you drive in violation of this affidavit, I will have a contempt. I can have a contempt hearing. I can have a contempt.
Judge, after.
Finish.
I'm so sorry.
Finish.
I'm a commercial driver.
Really?
Yes.
Really?
Yes.
You, if you do have a CDL,
Sorry, that is correct. She does have a valid CDL.
are held to an even higher standard because of that CDL. You now have a total of 4 open cases, one of those being this FSGI and an evading arrest in a motor vehicle. I am taking away your privilege to drive. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine. I truly
Here's the
am
outcome.
at
In the first matter, the judge found probable cause, emphasized the defendant's history and driving risk, and imposed strict conditions, especially the do not drive affidavit with potential contempt consequences. In the second case, the court accepted a reduced misdemeanor resolution with a 2-year deferred framework, protective order, no contact, classes, community service, testing, and 10 days jail as a condition, while still allowing the victim's voice on record. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom
I
breakdowns.
truly am at a loss with the attitude.
Okay.
Truly,
Okay.
this case here, not only do we have an FSGI, but it's also alleged that you backed up and hit the person intentionally. Because
No.
allegedly hungry and covered. So now, this is an affidavit, and I hope that you take it seriously. Because if you don't, there will truly be disastrous consequences. Ms. Gill, I want you to understand that I'm going to do everything in my power to protect my public at all costs. Do you understand?
I understand you, Your Honor.
May I make argument for a PR bond, Your Honor? She's made a bond in the felony already. And even with the affidavit to not drive, I expressed to her that that was a possibility of a bond condition. I've spoken with her. She has family members who can help her get to and from court. She's a single mother of 2 children. She has lived at this address here in Houston for the past 5 years. She lives with her mother. She lives with her younger brother. Has lived in Harris County her entire life. And she has, in these felonies, she's actually applied to be put in mental health court because during this incident and the felonies, she was unmedicated and she has a history of mental health diagnoses. And so as a client of the Harris County Public Defender's Office, we have every intention of getting her treatment for those mental health issues. But she's already made a bond in the felony, and she is willing to abide by any condition that this court will impose on her. It's down to the difference between $0 and $100. And
So I appreciate your argument. She's technically, you are right on bond. My feeling is that these felony courts probably do not know that she has now picked up this case yet. So I don't know what, if anything, they're going to do when they do discover this. I find, Ms. Goucher, right? Is that what, Ms. Goucher? I really appreciate your argument going to bat for her, but I think with her demeanor, her attitude, her reckless and wanton action on the road is that you are a danger to the public, and your bond is now set at 1,000, and I'm going to raise it to 5 because I think that you really are a danger to the public, and your attitude shows us and tells me that, hey, I'm going to do what I want to do, and that's it. And that's always, I mean, really.
don't say anything.
How many people died this weekend on the road because of the reckless and wanton actions? All we want are our streets to be safe.
You're not helping me, Your Honor. You're not helping
Don't say
me.
anything.
I'm struggling. I'm a single mom, and I've been struggling with the courts for years already, and I'm tired of this. Okay? I was beat, okay, in front of my children, and I was thrown on the ground like an animal, okay? And I'm tired of this. I'm tired of all of this, okay? In front of my children. My children have trauma, okay? And I have no insurance for the medication, and I have not been on the medication. I'm trying to get the insurance to get on the medication.
Ms. Gill,
Okay.
I understand that, but at some point, your actions become your own, right?
You don't understand. I'm colored. You don't understand me. You don't understand me. If I was a different color, you would. And it's true.
That's so
It's
not.
so true. It's so true. And you know this. You know what I'm talking about.
I call out discrimination when I see it on a daily basis, ma'am. I don't care who it is. I don't care what color. If they're a small farm animal, I don't care. I call it when I see it. The only thing, because I don't know them. The way I get to know them is paper. And they tell me what happens in the case. And from what I see here and what has transpired here within the last 10 minutes, really?
Officer Harris did not read me my rights.
Well, I will let
They've been mishandling me like this for years already, okay? I have the right to tell you this. And I'm telling you, she did not read me my rights. She just shoved me behind the officer car. I did not get a voice to speak out anything.
Yes.
She just brought me to jail.
You guys speak about that. I'll tell you, look, here's what I'm gonna do. I'm gonna leave your bond at $1,000 now. All right? I'm not gonna raise it to 5, but I can't continue to give you a PR bond.
Terminated from employment too.
Listen,
Okay.
do not drive. That's the only thing I'm asking you to do.
I'm a commercial driver.
Don't pick up a new
Yes,
case.
sir. Yes, sir.
And just, all right. Come on. Justin,
This is a plea. It was a felony case. We refiled it as a misdemeanor.
okay?
And there is a victim impact statement. The victim is not present. So I was wondering what the court wanted to do.
I don't want to do it. If they want to make a victim impact statement, then I want them here and we'll do it all together at the same time. Because I want that person heard as well. It's only fair. So,
They were unable to make it today. They had notice about today's court date.
fine, we'll set it for whatever day you want. Do you want to reach out to them to see what day is good for them and then we can do it? I mean, take your time. There's no rush.
Judge,
Really.
if I may, this case is 3 years old. We've had 7 trial settings. We finally resolved it to today, and then she can't come on the day of trial.
I don't know, Joe. I'm
But
just.
that's what I'm saying. I'm letting the court know. I think that's kind of unfair to
See
my
if they can
client.
Zoom, because I have Zoom.
We could ask her. I don't know if she has that ability.
You want to see? Want to stand down for a bit?
I'm sorry?
Just stand down to see if she's available to
She
Zoom.
is okay with someone from our office reading it in her place, if the court's okay with that.
It's the whole purpose. No? Can you reach out to her real quick and just see? I know you're in the home stretch, Jim. I mean, I know you've gotten a great deal here. They're reducing it to a misdemeanor, getting on it deferred. So just give me 5 minutes. Let me see if they can do that.
Yes, sir.
So,
Oh, hello, can you hear me?
yes, I can hear you.
Okay.
Okay, give me 1 second, ma'am. Give me 1 second. So procedurally, with this case, Joe, he gets charged with a sexual assault upstairs, or he's on bond for a sexual assault,
On bond.
and then he picks up an indecent.
No. Plea bargain down to a Class A indecent assault.
The felony court does not do misdemeanor probations, so we had to refile it as a misdemeanor. That's what the plea deal was, essentially.
So it was a reduction to a misdemeanor,
Correct.
indecent assault,
Correct.
to a 2-year defer.
Correct.
Okay. So let's do ma'am, what I was going to do is do the plea first and then have you say something after the fact, if that's okay. Are you okay with that?
Only if it's not allowed for me to speak first prior to the plea, then of course, yes, it's okay to speak
If you want to
afterwards.
speak first, then you're welcome to. Is there
Okay.
something that you wanted to say?
Well, I wanted to read my victim impact statement.
Please do. You're welcome to do it.
Okay, thank you. Okay, so I'm writing this statement to share how this experience has continued to affect me long after that night. There may be times where I actually need to take a moment to breathe, actually. Just wanted to go ahead and say that first. When I first submitted this statement, I was overwhelmed. I was still in emotional shock and unsure of what to say and how to say it. I've since come to understand the importance of expressing clearly, not just what happened, but how it impacted every part of my life. This event has completely changed me. I wake up with anxiety. I experience episodes of fear, confusion as to why I did not run, and constantly feel a loss of trust, not just in people, but in places I once felt safe and in myself. Every day I'm reminded of what I've lost. I lost peace of mind. I lost the ability to work without panic, the ease of everyday interactions. Every day I'm reminded of how I got taken advantage of and didn't react as I felt I would have in a moment like this. If this emotional toll has affected my professional life, my relationships, my physical well-being, I can't I can't control my heart rates in these moments of panic. There are true anxiety, full-on panic attacks that I experience still to this day, 2 years later. At the time of my first statement, I didn't have access to important documents, which are records that might have helped me explain myself more clearly within these 2 years. Since then, I've started the process of requesting my full case file from multiple agencies, medical records, and forensic testing. I have not received those as of today just yet, but I know those documents all exist. It's been over 2 years, and this case has been reset multiple times. A new prosecutor was also assigned only days before this plea was suddenly brought to me. The rapid timeline did not allow me to revise my statement or consult with anyone about how this offer would impact my rights as a survivor or my potential ability to seek justice outside of this criminal court. This statement is not about vengeance. It's about the truth. It's about my healing. It's about ensuring my voice is heard in a process that often feels designed to just move forward without it. Every day since this assault, I've struggled with anxiety, flashbacks, and trust issues that have reshaped how I live my daily life. I still cry regularly from this incident. I still shut down. I still replay everything from the pressure, the coercion, the force, the aftermath of where I try to survive it all without falling apart. And yet I still feel like I have to justify why it broke me. This wasn't just a violation of my body. It shattered my trust, my sleep, my ability to feel safe in my own skin. I've spent nights replaying what happened, and the fear and the disgust and the betrayal. What was taken from me was not just physical, it was psychological and it was spiritual. I'm a hairstylist, and my career is built on one-on-one trust with my clients. Since this happened, I've felt constantly on edge with male clients. I find myself backing away from simple interactions. I've lost my income. I've lost my confidence and my own safety in my own body. The job I once had, I lost due to being completely disconnected from my mind and my body. I now know that this man was on deferred adjudication and had a breathalyzer in that car, and yet that night he took his mother's car and drank heavily and violated me when I was in and out of consciousness. The defendant slapped my face during intercourse and violated me. His third time assaulting me that same exact night without consent. I remember him begging me again and again, and I kept saying no. But I couldn't get up. I pushed him away off of me again and again. That is not consent. Me freezing up was fear. That was survival mode that I was going into. And Your Honor, I ask that you consider what kind of system lets someone walk away with that and just probation. Even after all of this, I still had to let him drive me home the next day and bought me a Plan B pill. The defense says I had chances to leave, but how do you leave when your body and your brain have been hijacked by fear? The prosecutor told me that juries don't like women and that they don't believe us, and that broke me more than anything. I was told I could be blamed at trial for going to the bar or for texting him afterwards, as if trauma survivors don't respond in ways that help them stay alive. That's why I'm asking you now to please understand that this proposed plea is not justice.
Then I'm not going to take it. I'm not taking it, Joe. I'm not doing it. Sorry.
Just
I
because
have
she
more-
spoke first?
Oh, I mean, I don't know. All I know is that we have a powerful victim impact statement here. We have a sexual assault being reduced to a misdemeanor, 2-year deferred.
Correct.
Apparently, no one's consulted her regarding this thing, see whether they.
We have been in extensive communication with her this past.
No, sir. No, sir. I
About the
barely
plea
spoke
reasons
to you
for-
a couple of days ago, sir. I didn't even know you were on my case until Tuesday or Monday it was Tuesday when you first called me. I didn't even know Missy was not on my case anymore. And she gave me the confidence that this would go to trial. She believed we had a very strong case to bring this to trial. She didn't have any doubts in this case at all. And I meet Gabe just this Tuesday. And it's rushed into this plea without even without even discussing with me.
Okay. Thank you, Ms. Echevarria. I appreciate your testimony.
I really appreciate your honor letting me speak before you accepted this plea.
Absolutely. And I'm glad that you were here to speak, get everything off your chest.
Yes.
Anything you need, we're here for you, Ms. Echevarria.
I really appreciate that, your honor. Thank you for letting me get on Zoom, even though I could not physically be there.
Yes, ma'am. I will accept this, but I'll do 30 days as a condition. It's the only way I'm going to do it. So you guys can talk and see if there's something
I
that you
think
want
it's
to
unfair to
do.
my client because normally we do the plea, then we have the statement. Just because she spoke first, now she's gonna bust the deal?
She's not busting anything. I mean,
I'm
I
the
was-
victim. I am the victim. How do you even
Please.
speak about? Sorry.
Please,
Yes,
it's
sir.
okay.
He's been coming to every court date. We've been set for trial 7 times. We're actually set for trial this morning.
In the district court.
This is
I'm
the
sorry.
collision point between case management and human impact. Legally, reducing a felony to a misdemeanor with deferred adjudication can be a negotiated resolution. But listen to her. She's saying the timeline changed, the prosecutor changed, and consent to the deal felt rushed. The judge seems focused on making sure her voice gets heard, even if it complicates the plea. Question for you. Should victims have veto power over plea
In the
agreements?
district court.
I'm sorry,
In the district court.
in felony district court.
I get it. She feels like, one of the things that we need to take into account, is I'm not going to do it without 30 days as a condition. I'm sorry, Joe. So you guys can talk or we can set it for trial. It's your decision, Mr.
You do home confinement?
Home confinement? No. That's a gift. No,
Can we stand up?
please.
Okay. It's only 10 days, Judge. 10 days. Otherwise, he loses his job.
It's better than the current deal from our perspective.
Okay.
Thank you, Judge.
Good.
Okay. Come on.
And also, Judge, the complainant did not finish her impact statement. If she could be allowed to do that.
Yeah. Let me do this first. We'll go through with it and then. So, Mr. Camano, I'm also putting on a protective order as of today. Mr. Camano, you're charged with indecent assault. You're facing up to a year in jail and or a $4,000 fine. The agreement that you have worked out is a 2-year deferred with thinking for a change, sexual boundaries course, 50 hours of community service, no contact with Ms. Echevarria, and 10 days as a condition in jail. Do you understand?
Yes, Your Honor.
Is this what you want to do?
Yes, Your Honor.
You are giving up the right to have a jury decide whether you're guilty or not. You're giving up the right to cross-examine any accusers, confront any witnesses. You give up the right to appeal. Once you accept this agreement, you can never get out of this. It will continue until you complete this agreement or if you violate it. If you violate it, I will issue a warrant for your arrest. I'm going to bring you back over here. We are going to have a hearing whether you violated this. And if you do, you're looking at an entire year in jail. Do you understand?
Yes, Your Honor.
If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law.
He's a U.S. citizen, Judge.
Okay. How do you plead to the offense? Guilty or not guilty?
Guilty.
I'm not going to find you guilty. I'm going to withhold that for 2 years. You will be required to do the thinking for a change, sexual boundaries, 50 hours, community service, no contact with the complaining witness, no weapons, no drugs, alcohol, random testing. I want him tested in a week, please. If you're using, it's not going to go well. I'm going to tell you now, I'm going to test you like crazy. If I find that you're using, you're going to get a one-way ticket. Do you understand?
Yes, Your Honor.
Okay. Ms. Echevarria, did you want to say something else?
Yes, I'd like to finish my statement, please.
Okay, you may continue, ma'am. Shh.
Okay. Sorry, let me get back. Okay. I was 2 years up. Okay. So I have submitted requests to the HPD, Houston Methodist, and the Forensic Center to access police reports, my toxology, and my rape kit results. All things I should have had years ago. I just began accessing public records on my own because no one helped me understand I had the right to review them. And this is why I wanted to request a continuance. I do respectfully request that the court do require the conditions that prioritize accountability, rehabilitation, and safety, such as formal admission of guilt in court or via stipulation, no contact, and geographic restriction order, mandatory sex offender rehabilitation, and language in the plea agreement affirming that I reserve my right to civil litigation because I want peace and I want to heal and I want to know that my voice mattered. Also, Your Honor, I respectfully request that you do not proceed with that plea until I have had the chance to review the full case file, as well as all the evidence I'm lawfully requesting, including the police reports, toxology, and SANE results. I was not given the sufficient time to revise my statement, and I've had to teach myself how to access the court records after being left out of the process. This case was reset 7 times in the past month alone, and I was promised a trial, not a rushed plea. I'm asking that the record reflect my objection and that my request for a continuance be considered on the basis of my rights under CCP 56A.051 and 56A.052. If the court must move forward with that plea, I would request the formal admission of guilt, the no contact order, required sex offender counseling, and a clause affirming my right to pursue civil litigation.
What I will say, ma'am, I know that you are upset and I'm sorry that you are. I have no idea why it ended up here, but it is. The lawyers, I think, have been working for a while to try to resolve this. They've come up to an agreement. I did issue a protective order now so that there is one in place.
Yes, thank you.
So, and I've also ordered no weapons as well. So,
Is there any way he can have the sex offender counseling? I feel like very much so.
I don't have, that's not something that I have access to down here. That's only in the felony courts. So I don't get access to any of that stuff.
What about the formal admission of guilt from the defendant?
They have worked out an agreement where they're doing a deferred. So it's a deferred adjudication. That's something that you're going to have to get with the office about. I know that you have other avenues of recourse as well. I can't give you legal advice. The only thing that I would probably advise you is just go talk to a lawyer, you know?
And so trial is not able to go forward.
No, the case is done now. It's ended in a deferred adjudication just now, ma'am.
Okay, and he was previously on the adjudication, but what about, I still feel like I'm being silenced with everything that I've been saying.
The only thing I could advise you is go back to the district attorney's office and just start, talking to people there.
To the district attorney's office?
Yes, ma'am.
Judge, our first trial setting was March of last year.
I
This is the first time we're hearing about her asking for anything. And we've
No,
had
I was not.
after setting.
I was not aware.
Excuse me,
I
ma'am.
have all the
Excuse me.
texts of
Can
the.
you finish, please? We've had setting after setting. This is the first time we've heard anything about this from her. So I don't think that's
This
any
is not the
part of-
first time. I
Ma'am, let me
have
finish, please.
requested forms before. I have sent
Well, ma'am,
emails
look,
to get these
Mr. Chevalier,
documents and
I
I
don't
was
want to
not
get
granted.
I don't want to get into a big match about what's going on now. The only thing I can say is if you have any kind of disagreements, get back with the office, talk to go to the district attorneys and go talk to them and figure out what else. Like I said, there are other avenues. I can't give you legal advice. I can't tell you what to do from here. Okay?
Okay.
Is that it?
Yes, sir.
Okay. Thank you, ma'am. Okay, so
This is a huge moment. The judge isn't deciding guilt yet. He's saying there's enough probable cause to move forward. But notice what's really driving the reaction, the pattern. Multiple open cases plus prior felony probation changes the court's risk calculation fast. And that affidavit to not drive? It's basically one more move and it's contempt. What would you do here? Strict compliance or challenge the condition?